Welcome to Legal Lines. My name is Tom O'Shea, the host of this program that is brought to you by the York County Bar Foundation. My guest today is attorney Kristopher Accardi. Welcome, Chris.
Thanks, Tom.
And Chris is an attorney with the law offices of Dorothy Lividitis, and he is also the assistant solicitor for the Office of Children, Youth, and Families in York County. And that's our topic tonight, the Office of Children, Youth, and Families. So my first question is, what is the Office of Children, Youth, and Families?
Very good question to start off with, Tom. York County Office of Children, Youth, and Families is a county agency that is responsible for investigating referrals of abuse and neglect involving children.
Okay. Old-timers like myself will refer to it as Children Youth Services.
That is still a very common name in some areas.
Okay, so that was the name of the agency up until a few years ago?
Correct. I think within around 2012, 2011 is when the name changed.
Okay, so, but it's basically the same agency.
Correct.
And what is your role as a solicitor there?
I represent York County Office of Children, Youth, and Families in all judicial proceedings. Anything from protective service hearings, shelter care hearings, dependency hearings, all the way up through judicial reviews.
Okay. Now, can you tell us basically what the office does, what the Office of Children, Youth, and Families does?
Sure. So anytime that the office, YCOCYF is the acronym, or the agency is commonly referred to, whenever the agency receives a referral of abuse, neglect, or some other issue that a family might be having, they will conduct an investigation to determine if the allegations are true and if the family that they're working with need further services to help alleviate the concerns that brought the agency involvement.
So you're saying mainly it's for abuse or neglect?
Those are two of the terms. There's two types of referrals that Children, Youth, and Families generally receives. The first is a Child Protective Service referral, or a CPS. Those generally involve allegations of physical abuse, sexual abuse, or medical neglect. You then have what's called a General Protective Service referral, which could be referrals regarding other types of issues that a family might be having, such as parent-child conflict, lack of parental supervision, substance abuse by a parent, domestic violence, environmental concerns, various issues that are outside of the abuse and neglect realm.
Okay, now, so the agency helps families or children or families in these types of situations.
That is correct.
Okay, when you talk about you take referrals, can you explain that?
Sure. So a referral generally comes in two ways. It can come from the LegalLines registry, which is a state-run agency that anyone who has a allegation of abuse or neglect can call, make a referral, and that will get funneled from the state in Harrisburg down to the county agency. Once that's received, then we'll conduct an investigation, or someone can contact the agency directly.
Okay, now, you told me before we got here, and I don't expect you to have the number memorized, but the LegalLines telephone number is 1-800-932-0313.
That sounds right.
So, again, 1-800-932-0313. LegalLines, what is that?
LegalLines is the state-run agency and database where all referrals of child abuse, neglect, or other issues are received, stored, and the outcomes of those investigations are also kept.
Okay, so you said people make referrals. Who's allowed to make a referral?
Anybody can make a referral. The most common individual would be a mandated reporter.
Now, what is a mandated reporter?
A mandated reporter is any person who has frequent contact and is responsible for the care, supervision, or well-being of a child. For example, common mandated reporters are teachers, child care workers, medical professionals, children youth workers. Anyone who comes in frequent contact with a child is responsible for that.
So as a mandated reporter, if you suspect that there's either abuse or neglect, you're required to contact the LegalLines number.
That is accurate, yes.
But somebody who's not a mandated reporter and they believe that something is going on with a relative or a neighbor, or if they observe something that they believe is child abuse or neglect, they can contact the LegalLines number.
That's right as well.
Now, is this anonymous?
It can be, yes. You have the ability to remain anonymous if you wish.
Oh, is it automatic, or do you have to tell them you wish to be anonymous?
You would have to indicate or not share your information. For example, if I suspect that my neighbor is abusing their child and I call in, I could maybe say I'm a neighbor but not give my name. I could just say what I think is happening and not give any identifying information, or I could give all identifying information.
If you do give the identifying information, will they release it to anybody?
No, that is confidential. It is only allowed to be released to specific individuals or organizations designated by statute. For example, law enforcement. Children, Youth, and Families works in conjunction with law enforcement, as there's a lot of overlap in the investigations. So law enforcement or the district attorney's office would be permitted to know who the confidential informant is, or the confidential referral source is.
All right, so even if you give your name and say, I'm the neighbor and this is what I've observed, here's my name, they will not tell that to your neighbor.
Correct.
And let them know, oh, this is what came in this way.
Correct, and it's actually a misdemeanor to disclose that information.
So it will not be disclosed except to other people within the agency or law enforcement.
Correct, or anybody else who's designated by statute.
Okay. All right. So so somebody calls in, whether they're a mandated reporter or just a civic-minded person,
right?
And calls in and reports a suspected abuse or neglect. What happens then?
So once the referral is received by the county agency, an investigation is conducted. The agency or Children, Youth, and Families has 60 days to conduct this investigation to determine if the allegations are true. Allegations or referrals can end up in one of three ways. If it's a Child Protective Service referral, it can be unfounded, which means there wasn't enough evidence to determine if it was accurate or true. It can be indicated, which means that there was substantial evidence to determine that the allegations were true, or it can be founded. Founded means there's been a judicial determination that the allegations did in fact happen, such as a criminal trial, PFA, or some other type of judicial proceeding. An indicated finding can become founded at a later date. Children, Youth, and Families also has the ability to pend investigations if there is an ongoing criminal investigation or judicial proceeding, such as a criminal trial.
Okay. Now, we're already at the conclusion of what the finding is after the
Right.
investigation. But let's start at the beginning of the investigation.
Sure.
Number one, who does the investigation?
It would be a trained Child Protective Services worker or caseworker.
Okay. And is this a legal proceeding, or is it just something where a caseworker contacts the family?
It's an investigation, similar to like a law enforcement. It can involve judicial proceedings, but the investigation itself does not have to.
What happens during the investigation period? Is the child still at home with the same individual, or is the child taken out of the situation? What goes on there?
It depends on the type of referral received. It also depends on where the child is at the time of the referral. For example, if a child is alleged to have been abused by father, but the child is currently in mother's custody, then there would really be no need to remove that child from the parent's custody. Children, Youth, and Families will try to employ various ways to avoid involving the courts in the placement of a child. For example, sometimes families come up with their own plans on how to keep a child safe.
Is that known as a safety plan?
Or there can be a safety plan, which is an agreement between the parents and the agency as to how to keep a child safe.
So instead of, let's talk about what would the most extreme case be. There's a pretty good indication that the child is being abused significantly within the home by a parent. Is there a way that the agency would have the right to take the child out of the home even before there's an investigation?
Correct. If there's a urgent risk to the child's safety and well-being, the agency could file for emergency protective custody of a child, in which the county agency would take custody of the child and place that child in the care of the agency. Generally, it would be in either a kinship foster home or a traditional foster home.
What's a kinship foster home?
A kinship foster home would be individual who has a prior relationship with the child. Therefore, they would be licensed as a foster home, but they would have a relationship with the child. And the purpose of this is to minimize the impact of being removed from your parent's custody.
So it could be like a grandparent or an
Exactly.
aunt or uncle, or even a
family
babysitter
friend, right.
for a family friend. That the
Church
child has
member,
a-
pastor, anybody who has a relationship. Could have been a prior caretaker, a step parent, older sibling,
Now
whoever.
let's say that the agency believes this to be necessary. I assume that the parent being accused of the abuse has some due process. Is there any immediate hearing that they're entitled to?
Sure. So before we go any further, I just wanted, there are 3 different ways that an agency can take protective custody of a child. The first is by filing what's called an emergency application for protective custody with the court, and the court entering an order. If it's on a weekend or after hours, the agency could obtain a verbal order from a judge, which then has to be followed by an emergency application within 24 hours. The third way is, in certain circumstances, law enforcement or medical professionals could also take 24-hour protective custody, which then requires the agency to file a emergency application. Once the application is filed, a hearing has to be scheduled within 72 hours to determine if there's sufficient evidence to necessitate the placement of the child in agency custody.
So, and that would be in front of a judge at the courthouse.
It could be in front of a juvenile hearing officer, which is an attorney appointed by the courts to act as a judicial officer. If the parties wish, it could also be in front of a judge. It varies from county to county. In your county, our shelter care hearings or protective emergency hearings are traditionally in front of a juvenile hearing officer. However, the parties can elect to continue it in front of a judge. In other counties, it's in front of a judge right from the beginning. It just depends.
Okay. So there is some hearing process where a judge determines if there's sufficient evidence to say that the child needs to be protected and placed somewhere else.
Correct.
There's something else that people can do which is known as a safety plan,
That is correct.
and then keep it out of court.
It's an agreement. It can avoid court for a temporary period of time.
Okay.
A safety plan is an agreement. It has to be voluntary and knowing, made between the county agency and the parents of the child, in which the parents agree or come up with their own plan to keep a child safe. They can't last any longer than 60 days.
So, and that's the period of the investigation.
Correct, exactly. And it's meant to ensure the child's safety without the county agency having to take protective custody.
When we were preparing for this show, you gave me a good example. You said that there would be, an example would be a child who is allegedly being abused by mother's boyfriend,
Right.
who lives with mother.
Correct.
And the safety plan could very simply be that the boyfriend is not in the house until the investigation is done and has no contact with the child.
That would be one option. Correct. Yes.
And is it just assumed that the mother would follow that?
Well, they would have to sign affidavits of supervision. They would have to sign the plan. Also, there would be unannounced visits to ensure that they're complying with the plan.
So there's some way of ensuring compliance.
Exactly.
But that would be something that would be far less onerous, I would say, for the parent as well as the child, than the child being placed somewhere else.
It's less restrictive.
Less restrictive. So that's what I think that's a goal that the agency has.
Sure. County agencies recognize that removing a child from their parents' custody can be very traumatic.
Okay, we're running out of time on this segment. I'll be
Sure.
back to that when we rejoin the show.
Sounds good.
We'll be back in a few minutes. Welcome back to Legal Lines. My guest is attorney Kristopher Accardi, who is the assistant solicitor for the Office of Children, Youth, and Families in York County. And we were discussing that agency before the break, And one of the interesting things that I found out is that the law changed significantly after the Sandusky case up at Penn State.
That is correct.
And can you tell us what changes were in the child abuse law or law that affects your agency since then?
Sure. Around 2014, 2015, after the Sandusky scandal, there were numerous changes to the Child Protective Service Law, or CPSL, which included expanding the definition of who a mandated reporter was, as well as redefining what physical abuse meant, expanding the definition of other types of abuse and neglect. It also included more requirements for background checks on individuals, such as people who volunteer with children. It also included changes in changes in the definition of abuse. For example, if you leave your child alone with a Megan's Law offender, Tier 2 or Tier 3, that could be, and they're unsupervised, excuse me, I forgot that part. If you leave your child unsupervised with a Megan's Law offender, either Tier 2 or Tier 3, and you know about their registration, that can be defined as abuse as well. So there were a lot of expansions of definitions.
And people probably don't even think about that, but some, like, for example, if someone were to be involved romantically with an individual who was a Megan Laws offender, and they have a child, and after a while thinking, well, this person is safe because my child's been around this person for a number of months or so, and then say, okay, I'm going to the supermarket, can you watch the child? That could be considered abuse under the new statute.
It could be, correct. It does exclude the registrant's own children, but if it was like a stepchild, correct, that could be, after the law changed, that could be defined as abuse.
Okay, and you also mentioned that the law requires background checks for individuals, and I know from service organizations that I've belonged to or members of my family belong to, like if my daughter has children who are in school and she wants to go on a field trip, for example, as a parent,
right.
Chaperone, something that we did years ago, and you signed up and you did it. Now you have to have a background check.
That's right. Anybody who volunteers, whether it's paid or unpaid, who has any type of contact with a child and is responsible for their well-being, has to get a background check.
So that would be for a school group, a church group, Boy Scouts, Girl Scouts,
sports,
any type
right.
of sports team, coaching a team.
Right, exactly.
And that's a requirement. And by the way, I know some parents who don't get checked, so they don't have to volunteer to do that, but that's another story. But also, with respect to the changes in the law, you said that people, well, you were saying that the definition of abuse itself had other changes.
Correct.
And it has to do with the significance of the bodily injury, as I understand?
Sure. So one of the definition of physical abuse prior to the change in the CPSL was it was serious bodily injury. The definition was then changed to just bodily injury. It got rid of the serious part, which is defined as a temporary impairment of a bodily function or substantial pain. This was a lower threshold and easier to prove. Because of the change in the definition, as well as the expansion of other definitions, it has led to an increase in referrals. So that's one of the reasons why Child Protective Service agencies throughout the state and the Commonwealth are now receiving more referrals, because there are more things that under the old definition may not have constituted abuse, but now upon initial referrals could be abuse.
Okay, and you also said that after the Sandusky case, they broadened who's required to be a mandated reporter.
Correct.
Can you give an example of that?
You know, I can't think of anybody who was required to be a mandated reporter now that wasn't before. I just know that it expanded to include, for example, anybody who works at a medical
Yeah, prior
profession.
it would have been
Right.
a medical professional, but now it would include anybody who basically works at the healthcare center.
Correct.
So
Or at a
somebody,
school.
yeah, the same thing at a school. It would be a custodian. It could be the
Cafeteria employee.
cafeteria
Right.
employee, or
Exactly.
anyone else who they're mandated reporter now.
Right, because they're having contact
And I
with the
assume
children.
that these organizations, the schools and the hospitals, et cetera, are explaining this to all of their employees that they have an obligation now under the law to do that.
Most employers employ some type of mandated reporter training.
Okay. Okay, now we were talking about before the break, the investigation. You said there's 60 days for the investigation. Depending on the situation, there might be some type of safety plan in place during the investigation.
Correct.
Or in some cases, even the child is placed somewhere during the investigation. But you told us the outcome could either be founded, unfounded, or indicated.
Correct.
Let's say we have a case and it comes back indicated or founded. What happens next?
So the person who's identified as the perpetrator would have a right to appeal. If it's an indicated, they would appeal to the Bureau of Hearings and Appeals, which is an administrative judicial agency within the Department of Human Services.
Now, is that local or is it somewhere?
It's in Harrisburg.
It's in Harrisburg.
Right. You would have to file an appeal. There would be a hearing, just like in any other judicial proceeding. You would be allowed to present witnesses. You would be allowed to present exhibits.
Who is the presiding judicial officer for that type of hearing?
It's an administrative law judge appointed by the Department of Human Services, Bureau of Hearings and Appeals.
Okay, so that would be basically a court hearing, but not at the Court of Common Pleas level in York, but an administrative judge up in Harrisburg.
Correct. Exactly.
Okay, but other than that, it would function pretty much like a court hearing? It would be
Correct. It's a little more informal. There's different rules of evidence that apply. Anyone who's seeking to do so would be best served by either going to the self-help center or obtaining an attorney. They can definitely walk you through the process. But it's basically any type of other judicial proceeding.
And as the solicitor for the agency, you would be one of the attorneys who would be representing the agency at that hearing.
Correct. I was at one actually today.
Oh, okay. Okay.
So we're frequently up there representing the county agency in various appeals.
Okay. And this isn't a jury trial or anything like that?
It's a closed proceeding. The only individuals who would be there would be representatives from the county agency representative or attorney, the judicial officer, a court reporter, the appellant, and the appellant's counsel. Those are generally the only proceedings. They're closed proceedings. Other individuals are not permitted in.
But they would have the right to call witnesses, would they not?
Correct. Yep. The agency would have the burden, or the county agency would have the burden, which is substantial evidence to prove its case, and then the appellant would be permitted to present evidence as well, just like in any other type of proceeding.
Now this isn't a criminal finding. This is a civil matter.
Correct. It's an indicated finding is made with the child line registry. So if you were to do a search of person A in the child line abuse registry and they had been indicated for abuse, it would come up.
Okay. Now, let's say that either somebody accepts the finding or they appeal the finding up to the administrative judge and it's found that they still are the perpetrator of abuse. What happens next?
They could appeal to the Commonwealth Court of Appeals.
Okay.
That would be the next level of appeal. And
All right,
then
so
you could appeal all the way up to the Pennsylvania Supreme Court.
Well, assuming that there's no appeal or the appeals are exhausted, what does the agency do once it's been determined that there is a problem with either abuse or neglect?
It would then depend on what the safety concerns are in the home. For example, I'm going to use the example of the sex abuse that we started with earlier. If mother's paramour is accused of sexually abusing a child, his stepchild, and he's arrested and incarcerated, the agency would, most likely unless there's other issues, they would say because that person's incarcerated, there's no longer a safety concern. So the indicated finding would be made, but the agency likely would not accept for services. So after the abuse or the allegations are investigated, the agency would then make a determination about whether or not the family should be accepted for services.
And when you say accepted for services, what are the services?
Sure, there's a variety depending on what the issue's presented. So if it's a sex abuse case, it might be trauma counseling for the child. Depending on the age, there's different types of therapy. There's play therapy, music therapy, equine therapy, which is with horses. There's traditional, trauma counseling, like with a therapist for older youth. For the parent, it could be what we call non-offending parenting, where the parent gets educated on how to watch for signs of abuse, how to work with the child, how to protect the child in the future. If it's an environmental concern, like a housing issue, it could be an in-home team that would work with helping with a budget, connecting with community resources, working on parent-child conflict. A lot of our in-home teams comprise of both a family advocate and a therapist. So if there's parent-child conflict, the therapist would work with the family to address that issue. Also substance abuse and mental health counseling.
Who pays for these services?
It depends on the situation. Some of the services are contracted with the county themselves. Others are community-based services. For example, drug and alcohol services are routinely funded through outside resources, not through the children and youth itself. It might be a county-funded service, but it would not be through the children and youth budget.
Okay, is there any type of means test as far as whether or not the parent should have to pay for the services, or is it all paid by various agencies?
It depends on the situation. There could be certain situations where the parent may need to pay for something. For example, if a parent needs to get a threat of harm evaluation or a 5329 evaluation as known in custody court, that might be something that the parent would pay for on their own.
Okay.
There could also be financial assistance, though, for other services.
All right. So the goal, as I understand it, though, is to make the family whole again?
Correct. If a child is removed from the home, the ultimate goal of children and youth is to ensure the safety of the child, but also to help the family alleviate the concerns that resulted in the child being removed. So most of the time the agency is working towards a goal of what we call reunification.
Okay. So in many cases, and you said this in the first part of the program, the child is placed with a relative.
Correct. We strive for kinship
Okay.
resources.
And let's say there is a finding then of abuse by a parent, and the child is still living with the relative. Is something set up for the parent while they're going through the counseling and the program that's right for that parent to see the child?
Sure. So it would depend on the individual circumstances. Everything's case by case. There could be some situations where the trauma to the child is so severe that it would not be in the child's best interest. It would be too emotionally detrimental to the child. And that would usually be with the recommendation of a therapist that there not be any contact. Most of the time, though, we would start off with supervised visitation, because we do want to continue that relationship. Because even a parent who's hurt a child or has other issues, maybe it's substance abuse or that kind of thing, the child still has a connection with them. So we don't want to completely cut off the parent, because then the child might have, a negative reaction to that. They might blame themselves, they might self-harm, that kind of stuff.
Okay, and as you said, the main goal then is reunification with the parent and child.
Correct.
Okay, we have less than a minute left,
Oh, wow.
and one of the things you wanted to get out to the public is there is a website.
There is. York County Office of Children, Youth, and Families does have a website available for further information. You can Google it, just type in York County Office of Children, Youth, and Families, and there'll be a lot of other information that you can check out there.
Okay, well, thank you. Well, our time is almost up. I'd like to thank you for being our guest, Kristopher
Thanks for
Accardi.
having me. It's been fun.
And we were talking about children, youth, and families in York County. My name's Tom O'Shea, and this program was Legal Lines. Thank you for watching.